Hello friends, in the series on the income tax cases, today we will discuss a case which is based on the issue that if during the assessment proceedings, show cause notice is issued to the assessee for making the additions, and if the show cause notice gives a time which is less than 7 days, so whether in those cases can the whole assessment can be set aside only on the ground that the time given to the assessee for giving reply to the show cause notice is less than 7 days. This issue has been taken by the Honorable Delhi High Court in the case of Dauphin Travel Marketing Private Limited versus Income Tax Officer and others, and this case has been reported in 460 ITR at page number 589, and the date of the judgment is 5th July 2023. In the present case, the assessment relates to the assessment year 13-14. The matter is related to section 147 assessment. As all we know that there are circulars, standard operating procedures of the Income Tax Department which talks about of giving the minimum time to give reply by the assessee in consequence to the notices issued by the department. For example, there is an SOP which talks about that the first notice which is given to the assessee, that is section 142 subsection 1 notice for giving the submissions of the assessee, at least 15 days time should be given. And in the same SOP, it is said that for the further notices, section 142 subsection 1 further notices, at least 7 days time should be given, keeping in view the limitation period. Similarly, for the show cause notice, a minimum 7 days is required. In the present case, the assessee was issued a show cause notice dated 12th May 2023 in which less than 7 days time was given. It was also the plea of the assessee that the assessee has intimated the correct email ID to the revenue, but the notices were not sent to the corrected email ID which has been updated by the assessee. When this matter was before the High Court, because the assessment order was passed by giving the show cause notice for less than 7 days time, so the assessee filed a writ into the Delhi High Court. So Delhi High Court said that in the present case there is no doubt that the time given by the show cause notice dated 12th May 2023 is less than 7 days. Although assessee is also apprehending that the notices were not directed to the correct email address of the assessee, the court said that without getting bogged down by the factual assertion made by the petitioner that the notices were not directed to the correct email address, the court is inclined to set aside the assessment order solely on the basis that the show cause notice given to the assessee for giving its reply is less than 7 days. But at the same time, the matter was remanded to the assessing officer for fresh adjudication. Friends, as far as the questioning of the assessment order is concerned, no doubt the order given by the Honorable Delhi High Court is very favorable, because it is written in the law, it is a trite law that if the procedures are not followed, then all the consequential events which are there without following the procedures are bad in law. But at the same time, when the matter is remanded, it is very painful for the assessee, because it is seen that in most of the assessment proceedings, whatever the time frames are given for the officers, they are not adhering to that time frames, and only those assessees which are well worthy, which can afford going into the writ petition, they go for the writ petition and they get some relief in the name of following the principles of natural justice. But a small assessee who is not given the proper time to give the reply, their additions are being made and they have no option just to go into the procedure of CIT appeal, and that is very lengthy. So it means that it is giving a message to all the assessees that now the justice is only for those assessees which can afford litigation. But it should not be the case. The right way is that, with due respect to the various courts, that when the procedures are not followed, some cost should be levied on the officers. The matter should not be remanded back. They should be quashed from the scrap, so that it will give a message that they will not take it granted that the matter will be remanded and they can easily play as many as innings they wish. So, with due respect to the courts, we expect in future that if the procedures are not being followed, some decision should come that the assessment should be scrapped from the very basic level and they should not be given the second opportunity. At the end of this video, once again, I'm repeating the name of the case. The name of the case is Dauphin Travel Marketing Private Limited versus Income Tax Officer and others, and this case has been reported in 460 ITR at page number 589, and the matter has been decided by Honorable Delhi High Court. The date of the judgment is 5th July 2023. Thank you, friends.